I'm going to walk the country through a mere fraction of what has happened in federal litigation in the Northern District Court of California, particularly in discovery, after I filed a lawsuit pro se in June of 2022 for the despicable siege of Carmel Beach, which is a screenshot of what we're looking at here. And let me tell you, just batten down the hatches because you are in for one hell of a ride. This was a judicial notice I filed in the court in June of 2024, 6 months ago at ECF 198, and it goes into explicit detail regarding all the evidence tampering, concealment, and destruction of discovery we, the people, were always entitled to obtain. Donna Mario, the troglodyte that put her hands on me and removed my belt, wasn't wearing her body camera in violation of the police department's own policies at 450.5 that they must be worn at all times during investigative contact, and 450.5.2 that they must be kept running the entire time. Officer Boucher wasn't wearing his body camera either. The video surveillance footage from the back parking lot was never created. Officer Johnson activated and deactivated his body camera throughout my entire arrest, and the footage which would have shown the man getting slammed into the surf was blurred and tampered with and cuts off at some point just before that man gets attacked. I have been attempting to receive this cell phone footage from Carmel since August of 2021, and the second troglodyte we see here, Lisa Johnson, where the lobby camera footage of my second arrest shows her recording with that cell phone for a sustained 4 minutes, but what they sent to me in discovery was all of 16 seconds long, having clearly been tampered with, and their attorney responded by saying, "Oh yeah, that's all they sent to us." Officer Maldonado activated and deactivated his body camera throughout my entire arrest. During my second arrest, Chief of Police Paul Tomasi isn't wearing his body camera either. Lisa Johnson isn't wearing her body camera either. When Gerald Maldonado drove me to jail, I refused to allow my temperature to be taken, so I turned my head into the car, but he reached in to yank my head back by my hair so he could seal it anyway. The backseat camera footage ends right here, so they tampered with it just enough to edit that theft out. All the body camera footage sent to me, all of it, has been tampered with, which we're going to look at in a moment. Now, we'll have a look at Monterey County. I have been asking for the video surveillance footage of my arrest since January of 2021. I sent them an email again on July 22nd that I still hadn't received them. I sent a lawful notification on July 30th that if they didn't disclose them to me within 3 days, they would be included on an upcoming lawsuit. For my second arrest on February 26th, I requested the footage when a bunch of knuckle-dragging sheriff's deputies held me down in a chair and snickered as they attached things to my body and stole some of my readings and my jail cell footage from my second arrest. On August 13th, I told them they were required to preserve all the footage of both arrests. In 2021, the Monterey County Sheriff's Department sent me one response after the other about how they were in the process of collecting the records which may be responsive to your request, until, after bullshitting me for 7 months, told me I could go fuck myself because they weren't going to disclose any of it. Until, in federal litigation with the help of their pathetic attorney, Sam Beaterwell, they informed me that all the video evidence from my first arrest, all of it, the nurse's office, the room where you get molested, the garage, the jail cell, the booking room, the hallway, all of it, and the footage from the nurse's office and my jail cell from the second arrest were destroyed anyway. And everything I just showed you was entered into my case as exhibits and brought to the Northern District Court's attention in February of 2024. Then Carmel, the footage which points out the front windshield of when Boucher stuck his hands down my pants, was destroyed. Despite the fact that I asked for this footage 5 times in 2021, and I'll upload all those requests in another video along with a lawful notification delivered to the Chief of Police on June 25th of 2021 and repeated demands and emails to preserve it, with the full knowledge that litigation was imminent. The two other body cameras, other than Greg Johnson's, which we already showed was tampered with, that of Corporal or Detective or whatever these guys were, Michael Bruno and Jacob Clifford, were destroyed. Even in their own policy, 377.5 gives them clear instructions that if the recordings are evidence in any claim filed or any pending litigation, which there was. My lawsuit was filed in June of 2022, so it wasn't pending litigation, but active. They shall be preserved until pending litigation is resolved. This dovetails not only with California Government Code 34090.6, but the second footnote from Carmel's own retention schedule, and yet these discovery records were destroyed. All the other body camera footage around the country, all the critical incidents, all the footage of dumb officers implicating themselves in crimes are disclosed or at the very least preserved, but Carmel's all too eager attack on this innocent tourist who was invited to Carmel Beach only weeks before by the city manager, Chip Rarig, and the mayor, Dave Potter, is gone. Gone forever. They thought we were too stupid to care, or maybe that it would hurt tourism, or perhaps lose them their entire case. So Carmel threw them all out in the trash and took them to the dump. Radio dispatch from when all the officers laid siege to Carmel Beach was never created. The call I made to the police department on July 3rd was never created. And maybe in another video I can review as a matter of established policy. Monterey County and the Carmel Police Department have completely disregarded the law regarding when routine video recordings can be destroyed and delegated their destruction to AI when they are required to get the approval of both the government agency and the agency's attorney, which again violates 34090.6. Here's when I asked the city attorney, Brian Pyrick, and John Felix called him a turtle without a shell, for the video surveillance footage from when Johnson took my call on July 3rd, 2020. Pyrick wrote, "The DVD has two time periods when Johnson spoke to you. The city believes it contains the video you are requesting. In federal litigation, when the exact same record is requested, they tell me it never existed." Now, let's look at all the incontrovertible proof of evidence tampering which were entered into the case in the same notice at ECF 198. I was arrested on July 3rd at about 5 p.m. His body camera reads July 4th at, I don't know, what is that, midnight? This one has the wrong date and time because this is approximately 7 o'clock on July 3rd. His footage reads July 4th at 1:15 a.m. And another one, and this one when you can clearly see Maldonado's watch that it's 11:30 when Boucher's body camera reads 7:30. It is a felony in California for a peace officer to tamper with evidence as Penal Code 141B, and it also violates Federal Rule of Civil Procedure 37E. And what I just showed you is a fraction of the destruction, withholding, and tampering of evidence I uncovered, which were all reported to the court. And it began in January of 2024 during a discovery hearing. So let's have a look at the action Judge Cousins took in response to this document, which alerted the Northern District Court to the grave violations of Carmel's and Monterey's own policies, California law, my due process rights, and the rules of discovery. And for those of you not familiar with these types of documents, judicial notices and motions are entirely two different animals and adhere to a different set of rules. And nothing in ECF 198 requested an order, and that's why it was called a notice. So this is ECF 211 from Judge Cousins' order. This filing is procedurally improper. Under 7B1, a request for an order, including for judicial notice, must be made by motion. Okay, this is categorically false. There is nothing in 7B1 that mentions anything about a judicial notice. The motion must state with particularity the grounds for seeking the order and the relief sought. Furthermore, under Civil Local Rules 7.2 and 7.5, a motion must be noticed for hearing, be limited to 25 pages, be accompanied by a proposed order, and factual contentions must be made by affidavit or declaration. Plaintiff's filing at ECF 198 complies with none of these requirements. The court denies ECF 198 as procedurally improper. So not only does he take no action relevant to these felonies, but later in that same document claims that by reporting them, I was attempting to criminally prosecute, which I can't do because I'm not a prosecutor, and then threatens me with sanctions for exceeding page limits on a motion I never submitted because what I actually submitted was a notice. And incidentally, that same month, I mailed ECF 198 to the head honcho in the Northern District Court, Chief Judge Richard Seaborg, and he did precisely nothing about it either. Now let's talk about merely one of the multifaceted ways in which Monterey County screwed the pooch when they conspired with Carmel to do this to their people in 2020. Their supposed attorney, Susan K. Blitch, who swore under penalty of perjury that she was an attorney of record in October of 2022, when she only became one in July of 2024, nearly 2 years later. No matter how many times I demanded Cousins address this in what appears to me to be yet another felony, he continually blows it off again by saying such things as, plaintiff objects to Monterey's attorney Susan K. Blitch's failure to timely file an NOA upon joining this action as required by Local Rule 5-1C2, and by extension objects to her representation of Monterey and Monterey's motion to dismiss. In response, the court simply ordered Blitch to file her NOA, which she did the same day. I mean, is this guy for real? So she became an attorney of record nearly 2 years after she swore under penalty of perjury that she was one, and this is not of concern to you? This is not a big deal? Nevertheless, plaintiff renewed her objection, arguing Blitch committed, quote, an unrecoverable error and could not file a late NOA. The court has twice addressed similar arguments from plaintiff, concluding failures by attorney for the Carmel defendants to timely file NOAs did not prejudice plaintiff. The court likewise does not find the plaintiff was prejudiced by Blitch's untimely notice of appearance. Okay, all right, darling, sweetheart, these are your words, okay? Required. This is from your order that Blitch file one where you and your own local rules use the word must. Not may, not could, not whenever she feels like it. It's not discretionary. The words are required and must. And a few months before, he even said Blitch was just tardy. As though this is gym class in the 6th grade and not the people's rights at stake. Let's look at what happens to we the people when we fail to appear in court. We get warrants. We get rendered helpless in torture cuffs so a bunch of armed strangers can run their hands all over our bodies, including our private parts, and our fingerprints are entered into a permanent criminal history record before we are even presented before a judge or a jury of our peers. This court is saying in no uncertain terms that the rules are only for the little people, because when the one who rings the bell on learned counsel for failing to appear The courts, in their ever so polite way, tells the one who is harmed that she's really just blowing smoke up their ass, even when it happens repeatedly. I'm going to give people a brief overview of what happens when you file a Title 42 complaint in federal court. You list all the things your government officials did wrong, and then your opponents can file a number of responses, one of them being a motion to dismiss or 12b-6. That's when the officer's attorneys try to discount your complaint, saying they had the authority to arrest you standing on a beach, or they don't understand it, or it's a shotgun pleading, or whatever else they can come up with to get you kicked out of federal court so they can continue to allow the officers to violate your rights. If the court grants the 12b-6, it nullifies your complaint and is either dismissed completely or they dismiss it and you have to start all over again within the same case and go back to the drawing board. For me, this was 2.5 years of trying to convince the Northern District Court that everything they did that weekend violates the very principles which have kept us free for centuries in this country, and a bunch of sitting tyrants don't get to use violence and threats of violence because we want to go for a walk near the ocean. You can see by this point I'm already on my second amended complaint, or 3 complaints in total. My case was filed in June of 2022. After a pro se litigant figured out that the only attorneys for the Carmel defendants, Stephen J. Rothins and Jonathan Redford, just like Susan K. Blitch, also failed to appear until the end of February 2024, when this very same judge used the words required and must when referring to Local Rule 5-1, which governs appearances. But my research also figured out that Redford only became admitted to practice law in the Northern District at the end of February 2024. And lo and behold, Local Rule 11-1, which governs the requirement of becoming admitted to practice law in the Northern District, uses that same pesky word as Local Rule 5-1, that word being must. And in this document that we're looking at is when I first reported Redford's failure to both appear and become admitted to practice, and it was filed on March 20th of 2024. So did Cousins grant me a default judgment after he received this? No. Did he take the steps to have Redford disbarred for practicing law outside jurisdiction? No. Did he sanction him for this? No. Did he at least order Redford withdrawn from the case? That would be another no. What Cousins and the Northern District Court did after receiving this document on March 20th was to grant Redford's motion to dismiss 2 days later on March 22nd, thereby nullifying my complaint despite the fact that Redford had been practicing law outside jurisdiction for the entirety of my case. And this was after they had granted every single one of Redford's motions beforehand. And just a few days later, Cousins wrote that I was trying to deceive the court by claiming Redford's malfeasance had harmed me, even though he wound up backtracking months later, because I wouldn't let this point go either, to claim that Redford's error caused significant disruption within my case. Sorry, Your Honor, you can't have it both ways. Significant disruption within my case equals significant harm to me, as I wrote in my motion to vacate all of your void orders and judgments. So by August of this year, I just about had it to the back teeth with Cousins and started demanding he recuse himself of my case, overlooking the tampering and destruction of evidence, Blitch's, Redford's, and Rothins' failures and trespassings, and what I've reviewed in this video would account for the size of the slice of the pie we're looking at of everything else I uncovered, and it was all on the record when the Honorable Judge Casey Pitts swings in to save the day. In order to preserve confidence in the judiciary's fairness and impartiality, the court has conducted a careful review of the proceedings in this matter to determine whether there is any evidence of bias, prejudice, or partiality that would support disqualification. Based upon that review, the court concludes that nothing, absolutely nothing in the record could lead a reasonable person to question the impartiality of Judge Cousins.
What you just said is one of the most insanely idiotic things I have ever heard.
What Pitts is clearly saying, that the Northern District judges believe we are so dumb, we would buy that this obvious grift preserves the confidence in the judiciary's fairness and impartiality, and there is no evidence of bias, like none, not even a smidgen. And I haven't even touched on the shenanigans yet another judge in the Northern District, DeMarkey, pulled when I tried to settle this matter, but that will be for another video. And yet, in spite of all this, Redford's former firm, with the judge's assistance, continued to try and force me to disclose discovery. When every single interrogatory, every document they were trying to get me to disclose was submitted to me by Redford, who admitted in his confession that he exercised privileges in the Northern District Court for a period of time when he was not entitled to. And those privileges would include compelling me to disclose to his rogue replacement which dentist or gynecologist I visited within the past 4 years. In essence, the Northern District Court converted Redford's privileges into unalienable rights, which remained rights in a case he had trespassed upon even after he was withdrawn. And he was withdrawn by his firm on April 2nd, and yet 5 months later, at the end of August, his fake replacement is trying to stand on Redford's privileges, which had been converted into rights with the assistance of Cousins, in order to get my case thrown out. So it was probably around May or June, I stopped complying with any orders from the court when the jig was up and began protecting my own due process rights when it was clear as crystal by that point that the Northern District Court could care less about them, and I flatly refused to cooperate with the disclosure of any discovery when it had been established they were all submitted by an interloper. And in spite of Redford losing his 20-year partnership in the firm, in spite of me having to be the one to call all of this out because learned counsel, Cousins, and the clerk of the court failed in their own duties, in spite of 4 out of the 5 attorneys that attempted to attach themselves to my case since its inception had all failed to appear because I haven't even covered all of them here, in spite of all my reporting of the rampant destruction of evidence shown previously, including those exhibits and the defendant's withholding of discovery and violations of court orders to disclose that discovery, Judge Cousins dismissed my case because I didn't comply with discovery, even though all that discovery was submitted to me by an illegitimate attorney and law firm that are both under investigation by the court's own standards committee, which was entirely due to the amount of time I dedicated in unearthing and exposing how none of them followed the rules which were created to keep our courts civilized. So, we the people gotta ask, gentlemen, how can you issue rulings when your rulings aren't based on the rules? Nature, too, has rules. You break them, there are consequences. We have rules within our school system, our neighborhoods, our government, and perhaps most importantly, in our court system. They exist for a reason, to maintain order in a civilized society. If you are rewarded for bad behavior, that is a violation of the laws of nature. It's one of the reasons I stomped out there that day, because I saw our servants violating the laws of nature. And nature never ignores a violation of even one of her rules. The Northern District Court seems to have the erroneous belief that they can give their buddies carte blanche to operate outside the laws of nature. And we also need to ask, is this how federal courts around the country conduct themselves when being given the sacred duty of protecting our rights and freedoms, but has typically been hidden away because in nearly every other court case they are litigated by bar members? Yes, bar members. Bar members who are in the big club that the little people ain't in. That allows them to wheel and deal behind closed doors to ensure we continue to be victimized by those who bought their homes with our hard work. And they probably thought the joke's on us, because how would we the people ever be the wiser when those in the big club would never betray the bar or the black robes in exposing this to the public? I must have been something of a rude awakening for them, because they've relied on the people's ignorance and laziness to obscure the scheme, scam, and fraud they've perpetrated on us for only God knows how long, and they probably thought, and rightfully so, that their halcyon days of conducting this type of business in the shadows would go on forever. But it's a new year, Your Honors, and we the people are full of surprises. We know you've been accustomed to dragging cases out for so long that most people quit, but I do love being underestimated. It was short-sighted not to realize that those pedestrian old tactics wouldn't work on me, because all they've succeeded in doing is making me stronger and more determined and more aware of the incompetency and negligence of what I thought were the arbiters of justice, who turned out to be my opponents. But now, look what you've made me do. You've been exposed. Cause and effect is also one of the laws of nature. The truth is, I've already won fair and square. I know it, and you know it. Now it's only a matter of time. I trust that God has a plan, and perhaps one of the reasons I had to go so in depth was because Buccola versus Boucher is the great revealing.
Do not arouse the wrath of the great and powerful Oz. I said come back tomorrow.
If you were really great and powerful, you'd keep your promises.
Do you presume to criticize the great Oz, you ungrateful creatures?
I know you want us to just forget how you closed our playgrounds, our hiking trails, and our rest areas. Had the nerve to threaten us for standing too close to our fellow man. You stole businesses we had taken years to build and bound us in torture cuffs for committing the felony of shopping with the face God made for us. Sorry, servants, but not all the masters of the house have forgotten what you did. If anyone out there wants to help me to continue to administer peaceful discipline to those that swore to protect our rights, you can go here to donate or to my cashapp. This is for us, our children, and our grandchildren, so that what they did 4.5 years ago with arrogance and an illusion of impunity will never, ever happen again on our soil. Until that time, I am going to keep reminding the Northern District that they cannot invent reasons to scold us for violating rules we didn't even violate, while simultaneously deeming their own rules as irrelevant, unnecessary, and an absolute bother when their buddies actually violate them, and they try to convince us that all of you are above the laws of nature and we should be okay if you are rewarded for violating them. But just like I wrote in one of my last documents entered into Buccola versus Boucher,
rules. Exactly. Rules. Without them, we live with the animals.